Please be seated.
Good afternoon, Your Honor.
Afternoon.
You've had a long day already.
It's been a day.
It's been a day. Well, obviously, Your Honor, thank the court for scheduling us today on a very busy day. We'd also like to thank Mr. Hackman from the Office of the United States Trustee. We're pleased to report we've been working with him, and we have largely resolved all of the U.S. trustees' comments. I think we're down to just one outstanding issue with respect to what we're calling the 542E motion. Other than that, Your Honor, I'll move forward with some introductions. In the courtroom is Stephen Strom.
Mr. Strom.
He's the debtor's independent director and the declarant today. As you no doubt saw from Mr. Strom's declaration, he has substantial experience in restructurings generally, and in particular dealing with very challenging situations, and this may be one. On Zoom today, Your Honor, is Robert Wagstaff. He's the debtor's proposed CRO from Riveron. Mr. Wagstaff is on the ground in Cancun, is where the debtors are headquartered, so he is appearing by Zoom today as a result. From Young Conaway, Your Honor, I'm joined by a number of our colleagues, but I anticipate presenting today will be Sean Greacher, Allison Milkey, and Jared Kashanash. And the first lien lenders are here, Your Honor, and there are also our proposed DIP lender, Prudential and Cigna, and they're represented by Baker and McKenzie and Mr. Cousins.
In a while.
So, Your Honor, the circumstances we find ourselves in here, very recent governance change, lack of current financial information, reports of severe operational distress, serious concerns over animal health and welfare, aren't necessarily the standard set of circumstances that this court typically sees. That said, we think with Your Honor's help, as we get out of the gate here, and the use of the tools that are available under Chapter 11, we expect and hope that in a relatively short period of time, we will have this case on a more typical path, consistent with other restructurings before this court. Your Honor, the background, there's a significant amount of detail in Mr. Strom's declaration. I want to address just a few key points for the court's consideration. But obviously, if Your Honor has any questions or needs more detail on any specific point, we'd be happy to cover that. I do want to reiterate that, as Mr. Strom's declaration makes clear, some of the information in that declaration is dated because the company has not generated audited financial reports since 2022 and has not timely provided reporting to the first lien note holders. The most recent financial information that we've had access to is from the third quarter of 2023. Your Honor, the company is an international operation operating more than 30 attractions in 8 countries, primarily U.S., Mexico, the Caribbean, and Italy. These are recreational attractions, focus on dolphins or other live animal encounters under the trade name the Dolphin Company. Overall, the company has roughly 2,400 animals, about 295 dolphins residing at these facilities. The company employs more than 2,600 people, and in 2023 had 3.5 million visitors to their dolphin habitats, marinas, and water parks. The company has in excess of $200 million of funded debt. That's in 2 tranches of first and second. The first lien has been in payment default since January of 2024, so over 1 year. And the second lien has been in payment default since September of 2023. Additionally, Your Honor, there are credible reports indicating that the company has been without access to essential liquidity necessary to pay vendors, taxing authorities. There's reports that they've delayed or not paid certain wages and have not adequately provided for the health, safety, and welfare of the animals in their care. Again, as Mr. Strom's declaration indicates, the facts of all of these issues will be clarified as Mr. Strom and the management team gains control over the company's books and records. But given these serious defaults and concerns for the health of the business and the health of the animals, and really in the absence of prior management having any plan on how to address these matters, the first lien note holders, after exhibiting what appears to be significant patience, took steps to exercise their control rights and remove the existing members of LIH's board. And they did so and then appointed Mr. Strom as the sole independent director. At that point, Mr. Strom caused LIH to retain Mr. Wagstaff as the CRO and Riveron as restructuring advisor. After that, the first lien note holders exercised their control rights in the equity interests of the Mexican affiliates to remove those entities' boards and appoint Mr. Strom there as the sole independent director for those entities. And once that was completed, Mr. Strom removed the remaining debtors' boards and appointed himself as the independent director there. Now, this process is ongoing. I know Your Honor has the org chart. Right now there's a total of 15 debtors, the lead debtor and 14 affiliates. We're taking steps now to replace the boards with Mr. Strom at the other entities, but we're following the proper procedures for the jurisdiction where those entities are incorporated. And some of that is taking more time to go through the process of replacing the board and installing Mr. Strom. But it is underway, and we do expect several more debtors to file as we effect that change. Now, the court may be wondering, why did the independent director and the CRO determine to file Chapter 11 now before they really had an opportunity to get their arms around the business operations of these debtors? There's really 4 reasons, Your Honor. By all accounts, the company's in dire financial position. They've been in payment default, as I indicated, on the first liens for over a year. In discussions with the first lien note holders, they made it clear that they were prepared to lend to this company, but only with a management change, and inside of a Chapter 11 where there could be appropriate transparency. They were also clear they would not be primed on their first lien debt. There are animal safety concerns, Your Honor. Reports of dolphin deaths, particularly in the last 6 months, and government action to investigate alleged animal abuse concerns have caused a very difficult situation that we want to try to address immediately. Legal actions, judgment liens are all starting to pile up, whether it's eviction proceedings, efforts to collect past due amounts, or attachments. There are significant legal actions going on. And Your Honor may have noticed that the prior management commenced a concurso mercantile, similar to a bankruptcy in Mexico. That was, again, filed by the prior management. In our review, Your Honor, we can't see that the company that filed had the requisite corporate authority to commence a concurso mercantile. But really more importantly, Mr. Strom has determined that such a proceeding can't really create the platform for the global restructuring that's required here. It deals with only one entity in Mexico. I can give you an update on that proceeding, Your Honor. On March 31, new management did move to withdraw the concurso mercantile. There was a hearing yesterday and continued to today, and it recently ended. And we expect a ruling very soon. But the current management has asked to withdraw from that. If withdrawal is successful, we do intend to file that entity as a sister company with the current debtors. So really, in sum, Your Honor, given the substantial financial uncertainty, the ongoing lack of transparency and responsiveness to animal safety, the legal proceedings, the filing of a Chapter 11 proceeding to invoke the automatic stay and to allow the new the new director and CRO, the breathing spell to do the work necessary to get their arms around this company and put it on a path to maximize value. So what does success look like in this case? We see it playing out in 3 phases. First, stabilizing proper management and oversight of the business. That means what seems like some basic stuff, Your Honor, getting eyes on the parks, access to bank accounts, access to email and the servers. Really basic but critical stuff. Top of mind, animal safety, Your Honor. We can't say it enough. We're very concerned that the lack of liquidity has caused a situation where the animals are not being properly cared for. So we want to get in there and find out and do what we can to make sure that's fixed. So success in phase 1, Your Honor, is that the animals are safe, they're properly cared for, employees are paid on time, vendors are paid for their post-petition services, and the company operates in accordance with the obligations of Chapter 11. We're already actively looking for allies in what we call a must-succeed project of animal safety. Hopefully we'll find those people within the company. We're also looking at consultants outside the company, and we've begun to reach out to those individuals. And we're looking for people who will share the goal and help us do what's necessary to keep these animals safe. Sort of must-succeed project 1B is getting our arms around the financial operations of the business. Again, this means fully understanding cash management, where are the bank accounts, emails, servers, employee payroll, vendor services, and really other goods and services necessary to avoid a shutdown scenario that would both hurt the value of the business and put the animals in further danger. So we're hopeful that we're going to be able to take the steps necessary to make this happen as quickly as possible. Mr. Wagstaff, as I indicated, is in Cancun with his team from Riveron, doing what they can to push this process forward. But the relief that we're seeking today will be very helpful and a first step in sort of implementing phase 1 of this plan. We want to do everything necessary to comply with the bankruptcy code, obviously, and really in turn determine the best path forward from an operational standpoint for this company. So as you'll hear in connection with the DIP financing motion, the first lien note holders have stepped up with an emergency funding opportunity that the company can use to address the dire needs as they are discovered. We have some buckets, we call them, of where that funding can be used, but we are working on a more comprehensive DIP budget, and we have 15 days to do that. We're hopeful that we're going to get access to the information to provide the court, creditors, and everyone else involved, all the other stakeholders, with a budget that we can use the DIP for. That's phase 1, Your Honor. We then move to phase 2, and that's estate value maximization. The debtors have already contacted investment bankers with appropriate experience for a company of this type, and interviews are scheduled shortly. After we've ensured that the animals are safe and being cared for, and we have our arms around what assets the debtors have, Mr. Strom, his advisors, will determine how best to maximize the value of the business for the stakeholders. Success here means generating as much value as possible from these company assets. Phase 3, Your Honor, is sort of down the road. It may even be part of a Chapter 11 plan process. That's a full investigation, accounting, and reckoning of the historical issues related to these debtors. Looking at potential state causes of action against third parties. Success there will be to identify those causes of action, Your Honor, and to allow stakeholders to understand what happened here and to seek recovery for the estate, for those stakeholders. So in sum, Mr. Strom and his team are beginning to form a strategic plan for the debtors that will not only stabilize but hopefully improve animal welfare and operations, optimize the performance of the core assets, identify non-core assets for disposition, and restructure the debtor's liabilities. Now, we expect those who are in a position to cooperate with this process will fully and promptly do so. If they do not, and if their actions or inaction jeopardize animal welfare or the safety of employees, we'll be back in front of this court. Again, the relief we seek today is the first step in that process. As we get better information on her, Your Honor, we promise we will provide the court updates and other parties so people understand how things are progressing. Again, depending on the urgency of situations, we may be bothering Your Honor for some emergency relief. We apologize in advance for that imposition. We're going to try to organize this as best as possible and try to resolve as many issues as we can out of court. But if we need to come to the court, we'll be in contact. So hopefully this context helps the court's consideration of the first days we have today. I'm happy to answer any questions Your Honor has.
This is helpful, and I did read the filings. I noticed the situation in which the debtor found itself and how the lack of institutional knowledge that the current director and the CRO have, understandably, because they weren't involved. And I hear that the CRO, his name?
Mr. Wagstaff.
Thank you. Mr. Wagstaff is in Cancun, which is the headquarters.
Correct.
And so is that where all of the books and records, such as they are, or the access to computer records is?
We expect that, Your Honor. There may be, there are U.S. facilities in Miami and other places in Florida. So there may be books and records in more than one location, but certainly the corporate headquarters is in Cancun, and that's where the Riveron team and Mr. Wagstaff are focusing their efforts now.
And is there any kind of operational staff that's still in the Florida locations?
Yeah, the Miami Seaquarium is still open, as is the facility in Panama. There may be a few others. The Panama facility has been the subject of some action by the State Attorney General for concerns over animal welfare, but I believe it's still operating, and we've been in touch already with the Attorney General's office in Florida, and I believe we have a call tomorrow morning with them to explain the company now has access to more liquidity. We're going to get in there and make sure that we make the changes to that property that are necessary.
Well, obviously, you've identified the paramount importance of the animal welfare, as well as paying employees, et cetera. But I assume that there are regulations in the various states or in various countries with respect to animal welfare.
Yes, Your Honor, and the company has a staff that can handle this. We need to get access to them and find out who's going to stay with the new management team to help implement changes and use this new liquidity to make sure that we're properly caring for the animals.
Yeah, I would hope that there would be internal and on-site records with respect to the animals.
Yep.
And I sort of, in thinking of this, viewed it sort of like, when you get a nursing home bankruptcy or you get a hospital bankruptcy and there are residents and there are patients that need to be taken care of. And there are often state regulators who are quite interested in what is happening with those debtors.
Yes, Your Honor, there's plenty of news reports to look at to indicate there's reason for concern here. And then again, that's a reason that we filed so quickly to get access to liquidity to be able to make some changes.
Okay, thank you.
So with that, Your Honor, unless you have any other questions, I'd move the admission of the Strom Declaration for purpose of this first day hearing.
Is there any objection? Hear none, it's admitted.
All right, thank you, Your Honor. I think Mr. Kashanaj will start off the agenda.
It's your lucky day, Mr. Kashanaj.
I just dropped all my papers. Good to see you again. For the record, Jared Koshinosh, Young Conway, Sargon Taylor on behalf of the debtors. I sympathize with Your Honor. We'll get through it together. Hopefully, the few motions that I'm presenting are a little bit more straightforward than what we discussed at the previous hearing. But obviously, if you have any questions, ask Mr. Brady because he owes me big time. But
I think you're right.
But anyway, thank you, Your Honor. And I'd like to reiterate Mr. Brady's thanks to Mr. Hackman. He's been very responsive in getting us his comments, and as always. So I'd like to kick it off with, as usual, the joint administration motion. As Your Honor saw, we had 15 debtors that are affiliates within the meaning of Section 101 of the Bankruptcy Code. For the reasons set forth in the motion, joint administration is warranted under Local Rule 1015-1. And importantly, we are seeking this relief for procedural purposes only, and procedural consolidation would promote the efficiency of these cases. And so, unless you have any questions, we would request that the court enter the order.
I do not. Does anyone wish to be heard with respect to the joint administration motion? I hear no one. I reviewed it. It's appropriate. I will grant it.
Thank you, Your Honor. The next item is number 4 on the agenda, and that is the debtor's application to retain Kurtzman Carson Consultants doing business as Verita Global as a claims and noticing agent for these cases. The debtors have over 200 creditors and in excess of 1,000 notice parties in these cases, I believe. We are still running down the notice parties, but it could be potentially over 1,000. But under these facts and our local rules, the debtors are required to retain a claims agent. Also consistent with the court's claims agent retention protocol, the debtors solicited 3 proposals to serve as claims agent in these cases. After reviewing these proposals, the debtors selected Verita based on its competitive pricing structure and expertise. And I should note that there was a notice of revised order that was filed. I believe we have the red lines that I can hand up to Your Honor.
Please. I haven't had a chance to look at anything that was revised.
I've been advised that I'm handing you all the red lines. Thank you. So with respect to the KCC retention, there was just two changes. One was to attach the engagement agreement as Exhibit A to the order and to change the term Verita to indemnified parties throughout the order in connection with the indemnification provisions.
It's a broader term, I take it.
I believe so.
Okay.
Unless Your Honor has any questions, we would respectfully ask you enter the order approving KCC as claims agent.
Do not have any questions. Does anyone wish to be heard? I hear no one. I reviewed the application, and I see the revised form of order. It all looks in order. The debtors follow the protocol, and I will approve this as revised.
Thank you, Your Honor. The next item for your consideration is the motion confirming the worldwide automatic stay. I believe Your Honor is familiar with these sorts of orders. They're typical in cases with foreign vendors where we obviously have a lot here who are not necessarily familiar with Chapter 11 proceedings, and so a comfort order is typical and we believe necessary and appropriate in these cases. That was also subject to some U.S. trustee comments that I see Your Honor is reviewing. Happy to answer any questions. There were not too many changes. One was to strike one subparagraph of paragraph 2 of the order, and Mr. Hackman requested the addition of what is now paragraph 11 in the order.
I had a question on paragraph. I see these changes, which were also items I have flagged, and because I view these motions as really just a repetition, if you will, of the code, but not enlarging provisions of the code, but simply just restating, or as this paragraph 11, it says, it's declarative and intended to be coterminous. That's a good way to say it.
Yes.
Paragraph 3. Courts of competent jurisdiction shall take all appropriate measures required to enforce and recognize the Chapter 11 cases. Sounds like I'm mandatorily ordering some other court to take some action. And I don't know that I have seen this type of provision in one of these orders. So I have a concern there. And maybe it's with the shall nature of that sentence.
It's a fair question. Okay. We can change it to may.
Okay. Thank you. Paragraph 7, I had a somewhat similar concern because it talks about foreign governmental units, but I guess it's qualified by 525. So with that qualification, I'm okay with that language.
Understood. Thank you, Your Honor.
Did I ask if anyone wished to be heard?
I don't believe you did.
Does anyone wish to be heard? I don't hear anyone. I did, as you can tell, I did review this motion. I do, as I said before, consider it to be a comfort order and coextensive with what's in the code, recognizing, as counsel has stated, that foreign parties in interest do not necessarily understand how the code works. With the change that I've requested and that's going to be made in paragraph 3.
Yes, we are changing courts of competent jurisdiction shall to courts of competent jurisdiction may.
Yes, that was my only concern. And with that change, I will approve it as revised to reflect the comments from the Office of the United States Trustee and my requested change.
Thank you very much, Your Honor. The last item that I will be presenting today is the motion to authorize Robert Wagstaff as foreign representative. Section 1505 of the Bankruptcy Code allows a debtor in possession to obtain a court order authorizing a trustee or an entity to act in a foreign country on behalf of an estate created under Section 541. As a CRO in these cases, Mr. Wagstaff is well positioned to represent the debtors in a foreign proceeding and to serve as a foreign representative to ensure that any such proceedings are well coordinated with these Chapter 11 cases. Also, authorizing Mr. Wagstaff as foreign representative will avoid the added expense of retaining a third party to act as such. I'd also note, as Mr. Brady laid out in his presentation, there are a lot of unknowns in foreign jurisdictions, so there is a chance of immediate and irreparable harm if Mr. Wagstaff is not appointed and is able to act quickly, especially with respect to the concurso. So with that, we believe it is appropriate to enter this order because there is a substantial risk of immediate and irreparable harm to the estates.
Thank you. Does anyone wish to be heard with respect to the foreign rep motion? I hear no one. I reviewed it. Given the international nature of this debtor, there certainly may be need, and already apparently is a need, to have a foreign representative who can represent these debtors in other courts as necessary, and I will find it as necessary to avoid immediate and irreparable harm in the context of these cases, and I will approve this. Was there any change to this order?
I don't believe so. I believe Mr. Hackman just had a question that we answered offline, but I believe that this was as is.
Okay, thank you. And it will be signed as submitted.
Thank you very much, Your Honor. That is it for me for today. I'll cede the podium to Ms. Milkey.
Okay, Ms. Milkey.
Milkey LeBlanc, Your Honor. Good afternoon. Your Honor, for the record, Allison Milkey for the debtors. As you've heard this afternoon, the debtors are in a period of transition. By all accounts, they have been running on fumes, desperately in need of financing and leadership. As part of the recent management transition, the debtor CRO has begun to address these issues as Mr. Brady has identified. They first did that by securing DIP financing, which my colleague Mr. Greacher will speak to shortly. Second, they addressed these issues by immediately flying to Mexico to assess the conditions of the debtors' facilities, including the debtors' most sensitive assets, their dolphins, sea lions, manatees, seals, and other animals, to help to transition the operational leadership through meetings with the debtors' workforce, with banks, with accountants, with lawyers, with vendors, and with customers. Mr. Wagstaff is a highly experienced individual. He has a unique set of skills for this assignment. He is bilingual. He has previously lived and worked in Mexico, and he has contacts in the region. However, notwithstanding these exceptional characteristics and circumstances, Mr. Wagstaff will most certainly face, and already has faced, significant challenges in taking control of an operation that has been run by the debtor's former CEO since its inception, and has by all accounts a very small, closely held leadership team, or closely held organization with a small leadership team. While the debtors and Mr. Wagstaff will be commercial and respectful in their efforts, employees may not welcome this transition, and they may not be cooperative. Former management may attempt to thwart the process, and employees may not want to speak with the new management for whatever reason. It is critical that Mr. Wagstaff and his team have access to the books and records of the company, to information related to the debtor's properties and facilities, and to the debtor's financing. As you've heard, we are at a deficit in terms of information, and the lenders in this case have not received financing information for a long time. And it's imperative that Mr. Wagstaff and his team have full access to the debtor's books and records and any other information, whether that's maybe not the debtor's books and records, but still related to the debtor's books and records, like credential information or other types of access. This will provide Mr. Wagstaff with an additional tool in his arsenal to help him, importantly, feed and manage the animals, to maintain the facilities, to construct a budget, and ultimately to run these Chapter 11 processes, which, as we all know, requires a substantial amount of diligence and reporting, which is onerous even in the best of cases. And that is why the debtors filed their motion at docket number 7 for an order requiring that the debtor's former and current management and workforce provide records and information relating to the debtor's property and finances, to specifically Mr. Wagstaff and the debtors, and particularly for use in discharging Mr. Wagstaff and the debtor's responsibilities in these cases. Now, I will acknowledge this is not routine relief, certainly not on a first day. And 542E is a lesser-known code provision, this is not something you've probably seen before, particularly in a first-day setting.
Not in first day.
However, the function of 542E is befitting of the current circumstances. And I would say, Your Honor, that these are exceptional circumstances, and it's not relief that you'll see us come back to you trying to achieve in a run-of-the-mill case. As we know, 542E is directed to persons that hold record information, specifically books, records, papers, and documents relating to the debtor's property or financial information. It requires that a person disclose or turn over such information to a debtor in possession. It's unlike Rule 2004 in that it's significantly more narrow. The records that are disclosed relates only to the debtor's property or financial affairs. And the debtors here, as I mentioned, are not seeking information as a fishing expedition to garner documents in support of claims or causes of action or other matters which might impact third-party economic rights or claims or defenses. Rather, this is to obtain information to run the cases, to operate the business. It's to administer the cases, which is the standard under 542E. And in this case, it's a matter of imminent importance. There are approximately 2,400 animals in the debtor's responsibility. They require food, they require care, and the debtors need this information in order to be able to ascertain what food requirements are necessary, what care requirements are necessary to put in place, the individuals that will be necessary to continue to manage them, and to respond to things like the Attorney General's investigation or, frankly, just to run the business. Because it's a critical matter of importance for those animals, but not just the animals, also the payroll, ensuring that employees have the information that they need to come to work every day and to continue to create in an atmosphere that the debtors can continue to run their businesses and preserve value. All of these things are critical. And it's not a matter for 2 weeks from now. It's a matter for yesterday and for today and for tomorrow. Mr. Wagstaff is on site currently trying to get access to the company's email systems, to their books and records, to the passcode, to the front door. All of these things are critical information that needs to happen right now. And we require the tools that, any tool that is available to us, understanding that this is a really important endeavor for preservation of the estates and administration of the estates. So while we would note that this is not typical relief, and certainly 542 does require notice and a hearing, we would submit that the standard for irreparable harm has been satisfied here, and that it's appropriate to enter relief on an interim basis now. Parties will have an opportunity to come back and object, and we are happy to set this for a final hearing, and parties will have plenty of time to determine whether there's an issue with the relief that we're seeking. But again, because the information that we're seeking is limited, it's directed towards former officers, insiders, employees, and it's specifically with respect to information related to the debtor's property and finances for purposes of administering the estate. Submit that this relief is abundantly proper and appropriate in these cases. I'm sure you have questions for me, Your Honor.
I actually don't. Having had to look at 542E recently in another context, so you get the benefit of that. I see the changes are that this is now an interim order.
Yes, Your Honor.
Okay. Does anyone wish to be heard with respect to the request under 542E? Mr. Hackman.
Good afternoon, Your Honor. May it please the Court, Ben Hackman for the U.S. Trustee. As counsel noted, we have one open issue, and it's on this motion. I thank counsel for the debtors and the lenders in working with us to resolve our comments on the first day pleadings. One of our initial comments on this motion was to request that the form of order be made interim, which counsel graciously accepted. The U.S. Trustee's position is that the relief requested should be served out on notice. Section 542E uses the phrase after notice and a hearing. We're sensitive to the animal welfare concerns that are present in the case and the need to access information. We're struggling to square an order directing people to turn over information within 5 business days in more or less an ex parte setting when the code says after notice in a hearing. We're not sure if failure to produce the information would expose employees to contempt proceedings. The U.S. As I read the pleadings that have been filed, there's no top 30 list that's been filed yet. I'm not sure the extent to which the creditor body has received notice of the cases themselves. As I read the motion, I did not see previous cases cited where this type of relief was granted. The U.S. trustee is prepared not to oppose short notice if Your Honor were amenable to this relief being served out on notice. But with that, unless Your Honor has any questions for me, I would rest.
Thank you.
Thank you.
I can respond briefly to that, Your Honor.
Please.
We grant interim relief on first days all the time for things that require notice in a hearing. The standard is irreparable harm, and I would submit that that's satisfied here. With respect to notice the employees, this is going to come, these requests are going to come probably in person. Of course, we'll provide notice to the extent that we absolutely can. If the concern is that somebody is going to, be, held in contempt as a result of failure to abide by the order, first of all, that's within Your Honor's control. And certainly, Your Honor can address that as a remedy to the extent somebody comes in and we have a fight about whether something should or shouldn't have been turned over. Moreover, the statute requires that, obviously, privileged information is not to be turned over. So really, there's no reason here to think that information related to the debtor's property and finances shouldn't be turned over at this point. So if there's an issue with that, somebody will have an opportunity to come back and be heard, and Your Honor can determine what the appropriate remedy is.
Thank you.
Thank you.
So as I said, I've had the opportunity to deal with Section 542E recently, though we haven't issued an opinion yet on it. It isn't a statute that's often used, although I will say that I see it more in my Chapter 7 trustee cases. They seem to know that provision is here. And it is, I think, being used appropriately here with the request because what the information sought is the books, documents, records, and papers relating to the debtor's property or financial affairs, which is what this debtor needs. It does provide that this section, this application, this relief can be brought by motion, and it does say after notice in a hearing, and after notice in a hearing is addressed in Section 102, and Section 102 of the Code says that that phrase means after such notice as is appropriate in the particular circumstances and such opportunity for a hearing as is appropriate in the particular circumstances, and there's a but, it authorizes an act without an actual hearing if such notice is given properly and if, skipping a little, there is insufficient time for a hearing to be commenced before such act must be done and the court authorizes such act. So I think it is up to the court to take a look at the particular circumstances here, and I would hope as much of a due process person as anyone, but I think under the circumstances of this case, it is appropriate to issue this order on an interim basis. I will hear anyone who has an issue on an expedited basis if they come in front of me to argue that whatever it is the debtor is trying to obtain from them somehow is not records, documents that they hold that relate to the property of this debtor are somehow personal and unrelated to the documents of this debtor. But I agree what we're really addressing here is an irreparable harm issue, in that sense almost a TRO standard, And I think under the circumstances here where the welfare of the animals in particular is at issue, and where there is a concern expressed based on I'll say based on the lack of cooperation with the pre-petition lenders in terms of providing necessary and required information, as well as the need to immediately access the debtor's books and records. Under these circumstances, I'm going to grant this motion. And I do think it's appropriate to do it on an interim basis, and we'll set up a final hearing. But again, I will also hear any concern anyone has on an expedited basis. I do also expect the debtors, recognizing the unique nature of this relief, are not going to be pressing in front of me contempt motions in the first instance, or at the first moment they don't receive cooperation, but will in fact work with particularly the employees to get their cooperation. And I would hope that these employees, particularly the ones that work with animals, I would suspect have the welfare of the animal most at heart. But this may also give those employees some cover in terms of working with the CRO and our new director. So it hopefully will give them some cover to be able to do that on a cooperative basis rather than on a compelled basis. So for all those reasons, I will enter this order as revised.
Thank you, Your Honor.
Thank you, Your Honor. Good afternoon. Sean Greacher from Young Conaway for the debtors. We're now at item number 8 on the agenda, which is the hearing to consider interim approval of the debtors' motion for use of cash collateral, granting adequate protection to secured note holders, and for interim approval of the debtors' post-petition debtor in possession financing. As Mr. Brady said, motion is supported by Mr. Strom's declaration. We also heard from Mr. Brady and read from Mr. Strom's declaration the acute challenges the debtors are facing, financial defaults, significant uncertainty around critical operational issues, particularly in the areas of animal safety and welfare. Debtors have worked hard with first lien note holders. Unfortunately, note holders have stepped up to provide for the consensual use of cash collateral and access to emergency DIP funding under these extremely challenging set of circumstances. Funding that will, in our view, be necessary to protect the animals, to preserve value in the estates, and to help shape the next acts of these cases. There is, to put it plainly, a substantial and immediate need for use of cash collateral and DIP financing. Mr. Strom's declaration establishes unequivocally that the debtors have an immediate need for that money. I won't rehash the history here, but suffice it to say there's a history here. The Riveron team is in the process of getting access to the books, the records, the accounts. That process is ongoing this week. That process will be bolstered by the orders that Your Honor has entered, and we appreciate that. The business, as we said, involves various parks where living animals are located. While it's critical to get our arms around the business for a variety of reasons, it's absolutely essential to ensure that the health of the animals not be compromised. So without having any timely financials to rely upon, nonetheless, the note holders have stepped up to provide emergency funding. Given the urgency surrounding these challenges, the lack of available information, and the unwillingness of the first lien holders to be primed, it was clear that first lien note holders were the only likely source of funding today and under these circumstances. As mentioned, the debtor is in the process of interviewing potential investment banking candidates. Part of the investment banker's mandate will certainly to be a standard market analysis of DIP terms. We'll present the results and the conclusions of that analysis in connection with a final hearing, to be sure. There's one unique component of the proposed interim DIP structure here, In order to prepare a typical 13-week cash flow budget, one needs access to the data supporting such cash flow. So Mr. Wagstaff's team will obviously work toward that. We're working with Mexican Council, and we will use every available avenue to obtain that. So the interim DIP loan is a two-phase loan. The first phase is a borrowing of $1,500,000 prior to preparation of that initial approved cash flow budget. And the balance of the interim borrowing, up to $4 million, would be available after delivery of an initial approved budget. And the DIP order calls for that more traditional 13-week cash flow budget to be delivered within 15 days or such longer time as the required lenders will agree. We will, of course, file that budget with the court. So the first uses of the first $1.5 million will be to fund essential obligations as needed, including first and foremost costs related to the care and health of animals, costs related to providing transportation services for visitors to the company's facilities, costs related to the operational planning for security and logistics of Rivron's efforts in Mexico, costs related to obtaining access to books and records, estimated fees and costs of the professionals and of the claims and noticing agents, and other operating expenses. For example, I think as Mr. Brady indicated, potential costs of an independent veterinary consultant to assist the company, to assist the independent director and the CRO on appropriate measures with respect to animal health, costs of maintenance services, or other customer-facing services, and the like. As for terms, the DIP calls for payment of various customary fees, $70,000 of fees to the agent, as well as an upfront closing fee of $200,000, which will be picked. DIP loan accrues interest at 11%. Debtors are seeking approval of first priority liens on all property of the debtors' estates, including upon entry of an order of a final order proceeds of avoidance actions subordinate to the carve-out and permitted prior liens. The proposed DIP order offers what we believe to be reasonable and customary methods of adequate protection to the first liens and second liens, adequate protection, second lien lenders, adequate protection liens, and super priority claims. There are a small set of milestones related to entry of an interim order, selection of an investment banker, and ultimate entry of a final DIP order, a standard set of covenants. The interim order provides a carve-out for professional fees and disbursements for both the debtors and any committees appointed in the cases, as well as the U.S. trustees' fees. There is a request subject to a final order for Section 506C and 552B waivers and limitation of the scope applicability of the marshalling doctrine. There's a standard challenge period with respect to the pre-petition liens and claims. So, Your Honor, as you were having fun at your prior hearing, we did file a black line. I don't know if Your Honor has it. If not, I believe it should be in the folder. And subject to Your Honor's preference, I am happy to step through that black line. We did speak significantly with Mr. Hackman and addressed all of the comments that he has raised. So there are a number to go through, and I'm happy to go line by line with you, but obviously defer to your preference.
Let me ask a couple questions, please. First, I noted in probably in the declaration that there's a reference to 12 bilateral debt instruments. What are those?
I think if I don't know if the Council of Lenders have a view, but there are certain debt instruments with respect to a number of the foreign entities. Let me see if I can. One moment, please. Just make sure.
Thank you. the uplift.
Thank you.
Thank you.
All right, thank you. I just wanted to make sure that we were clear. And if I bungle it, please, hopefully folks will correct me. There are, we believe, and again, given sort of the dearth of books and records, we have reference to this in certain documents, but it appears that there are approximately a dozen agreements in various jurisdictions, foreign jurisdictions, that we would suspect relate to local payments, local obligations, transfers in and out of those entities. Again, this will be a subject of significant inquiry. We're not sure what those documents look like. We have reference to them, but we've not had the opportunity to study those documents. We don't have them yet. It will clearly be something that is on our list of materials to obtain and access so that we can understand that more thoroughly.
Is the DIP order doing anything to those documents?
Well, I believe, Your Honor, to the extent that those are prior perfected liens, no. So we're not priming to the extent that those are prior perfected.
Okay.
But again, certainly don't want to make any broad proclamations on documents that unfortunately we've not had the opportunity to see.
Okay. Normally, I don't look at the debtor stipulations because they're just stipulations. But it seemed to me in E Romanet 1 that that the debtor's making stipulations about a non-debtor and the lenders.
Yeah. So, Your Honor, I think that we are clarifying that was one of the clarifications that we've made in connection with discussions with Mr. Hackman. If you have the red line, I think what we're saying is that each pre-petition first lien grantor other than Dolphin, which is the non-debtor, joint and severally guaranteed as a primary obligor of pre-petition first lien secured obligations. Again, this is consistent with, I believe it's section 15.1 of the note purchase agreement. Obviously, that's a stipulation subject to challenge. But again, the notion here is that this order, is a stipulation of the debtors. The debtors are making this stipulation, and so the debtor is stipulating to their obligations here. There is no, from my perspective, and again, the proposed DIP lender will correct me, but there's no intent to stipulate on behalf of a party who's not before you.
Okay. Okay, I see some additional clarifications in Romanet 3.
Yes, Your Honor. This is of the same piece. Again, this is to clarify exactly what the debtor's position, the debtors who are before you, believe are their joint and several primary obligations under this facility.
Okay. Paragraph F, and I'm now on 14, cash collateral. That to me needs to be a debtor stipulation or properly in E.
I'll let the
What
counsel
constitutes cash collateral?
I'll let the debtor or the DIP lenders counsel respond to that. Certainly understood the point, but we'll defer to the DIP lenders on whether that's acceptable. And I'm getting a nodding head for the record.
With the yes? I was looking down. Thank you. Okay.
Ms. Khan agreed with me,
Okay.
as she is wont to do. that change, Your Honor.
Okay, paragraph, now I'm on page 15. It's 16 on the red line. Roll up, Romanet 3. So today, as I understand it, we're not approving any portion of the roll up. But this provision, there are several places where it talks about including the roll up. Is there somewhere that says, I hate these things, notwithstanding anything else, I'm not doing anything with the roll up?
I don't believe that we put such a provision in the document. I can certainly represent and would ask that the note holder counsel, the DIP lender counsel similarly represent. It is clearly the intention to have issues of the roll-up considered at the final hearing.
I think we should at least say subject to the final or something of that sort. Because otherwise I would just take it out. But
in the lead-in to Romanet 3, you'd like it to say subject to the final order? Subject to entry of the final order?
Yeah, which, I mean, it's talking about how it's being authorized. I understand what the lenders want here, but I don't think there's a place in the interim order. But if there's going to be something in the interim, we need some qualification on it.
I saw head nods, and I'm going to take them, Your Honor.
Okay.
We'll make that change.
Okay. A somewhat global comment. I first see it in paragraph I on page, it's like 16. The entry to this says, pursuant to the direction of all of the pre-petition first lien note holders, the pre-petition first lien agent has consented. There are other provisions in this order that talk about required lenders or majority of lenders or whatever. I don't know, because I don't have those documents in front of me, whether the agent has the requisite authority or not, and I don't get into whether the agent has a requisite authority. I assume it does, or otherwise it wouldn't enter into. But I've got those kinds of provisions all over here, all over this. And even more so in this provision toward the, I guess it's second to last sentence. Oh, no, that's a little different. Oh. The language at the end of the first sentence talking about consent is binding on all pre-petition first lien secured parties. I don't get into the interworkings of the lenders. So I would like those references to come out. I assume that, again, I assume the agent has the authority it needs, but I don't know that, and I can't confirm that. So that's a sort of a global comment to look for.
Okay, so just to recap, at the beginning of paragraph I, you would have a strike pursuant to the direction of all of the pre-petition first lien note holders, and then just start that sentence with the pre-petition first lien agent has consented.
Right, and then similar.
And then there's the language here, each of the pre-petition first lien note holders have expressly consented. I would strike that whole sentence.
Probably should be. And then it was interesting because it says each of them has consented, and then it says none of the remaining. Well, who would the remaining be if each of them have consented? So there's some internal inconsistency in there too, so I don't want to get in the middle of that.
Okay. So would Your Honor be willing to say none of the pre-petition first lien note holders has filed an objection?
Well, they haven't, so that would be true.
This is why I did so well in logic in college.
There you go.
Very good. So I believe that those were the offensive
Yeah, but you'll need to
here.
comb through this and just take a
But
look
we will.
for
We
that.
will, of course. We will, of course.
Okay.
Yes, similar. I see. Similarly, pursuant to the direction in paragraph
Yeah.
2, we'll make the accompanying changes there.
Okay. In we're in K, Romanet 3. It's been changed. Thank you. Okay, in paragraph 2B, DIP obligations, the last sentence, where again we're talking about the roll-up, we may need just some notwithstanding sentence, but the way I'm reading this, I just want to see if I'm correct, is that if there's something in the order that's contrary to the DIP loan documents, the DIP loan documents prevail. And that's not usually the default provision that we go with. But maybe I'm reading it wrong.
So, Your Honor, I read this as saying that the relative rights and priorities in the collateral is addressed by the loan documents. So your point is taken, but I believe it's limited to any dispute regarding relative rights and priorities of the roll-up DIP and the other DIP secured parties. Again, we will of course make that subject to the entry of a final order, but I believe that all we're asking Your Honor to say is if there's a dispute between roll-up DIP secured parties and other DIP secured parties, Your Honor would look to the terms of the credit agreement to resolve that limited dispute.
Okay, I guess I would hope that what's ever in the DIP documents is not has the same priority as what I'm granting here in this order, because I'm granting rights in collateral in this order. So,
Your Honor, we will strike it.
okay.
Strike the final sentence.
In paragraph C, it has the $8 million figure in here, and we're at I thought we were under the interim borrowing of up to 4.
That is correct. I think that we can modify that to just say $4 million for purposes of the interim order. So perhaps we could say the aggregate outstanding amount for all such borrowings authorized pursuant to this order shall not exceed $4 million.
And I just also want to make sure I'm correct, that all of the current debtors are guarantors under the pre-petition facility.
Correct.
Okay, question on, again, I'm still in that paragraph. It's the guess that's one sentence. It's the last sentence. And the way I'm reading it is it says that the pre-petition first liens are going to turn over to the DIP agent, the cash collateral, so that the cash collateral can be applied to the DIP obligations. But I thought the debtor was using cash collateral.
They are, Your Honor. Could have one moment
Yeah.
just to take a
And
look at it.
again, these are, I haven't dealt with these documents like you guys have, so I could be wrong.
Your Honor, perhaps we could put this one to the side and keep moving?
Yes,
And
yes.
we'll.
Yeah, that's fine. It's in paragraph G now. The pre-petition, in particular the second sentence, no, one, two, three, third sentence, all such fees, costs, indemnities, etc. I'll authorize the debtor to pay them, but I don't affirm or ratify expenses pre-petition or post-petition. It's on page
29.
of what I'm looking at, it is, yeah. It's
So is the concern with the word ratified in and of itself?
affirmed and ratified.
Affirmed and
yeah.
ratified?
Yeah.
I'll
That they
strike
can-
those, Your Honor.
Yeah. The question on there's been some changes to paragraph J.
Yes, Your Honor.
Um,
The clarification here at the request of the U.S. trustee is that the DIP liens are on the equity interests that the debtors directly own. We wanted to avoid any confusion with respect to
Yeah, not
100%.
not-
It is the
Whatever.
equity interests as they are held.
Okay, and are those currently collateral of the DIP lenders? I assume so.
They
since
are,
They've
Your
been
Honor.
exercising rights. Okay.
best of our information, the answer is no.
No. Provision in the adequate protection, 3A, Romanet 2. What I'm looking at, it's the bottom of page 37.
Yes.
After the bold, paid in full, repaid in full. The provided, however, is all of this consensual about plan treatment? It's a little unusual to have this in a dip.
With respect to the statements that the adequate protection claims may be impaired pursuant to any Chapter 11 plan?
Yeah. I mean, if it's consensual, I don't have a problem with
I know
it.
that we've worked hard to make this consensual, so I'm looking for a head nod, and I just received it. Yes, it is consensual.
I notice that there are references to first day orders. We don't obviously have operational first day orders yet. I would just caution that the operational first day orders should be consistent so that there is no inconsistency between priorities given and this. So if we need to make adjustments to first day orders, we need to do that.
Understood, Your Honor, and we will resist the urge to state that the relief granted in those orders is consistent with this order.
I don't know what paragraph we're in. I'm at Romanet 7. The next time you see a Romanet 7, which I think is in,
Titled Consent to Priming and Adequate Protection?
yes,
I'm there.
okay. The proviso, what does that mean?
Happy to give you my read on it, Your Honor, but defer to the DIP lenders who've requested this. My understanding is that the consent here, given the circumstances of these cases, is being granted under the totality of the circumstances here. It's being granted to these debtors that are subject to the possession and custody management, if you will, of Mr. Strom and the oversight of Mr. Wagstaff.
And I don't have any issue with that. But provided further that such consent shall be of no force and effect if this interim order is not entered, I guess, but this would assume it was entered, or is entered and subsequently reverse modified, that means they gave their consent now, but if this gets reversed, they didn't give their consent? I just don't understand what that means. I mean, I get that we're not going to consent anymore. If it gets reversed on appeal, we don't consent. And if the judge doesn't enter the order today, whatever consent we've been working among is ended. But I guess I don't understand how this would work, what this means.
I guess, Your Honor, imagining a parade of horribles, that for whatever reason, Mr. Strom were not here, and the debtor were here seeking to ask for entry of a similar order. And again, I don't want to put words in the DIP lenders' mouths, but this process was carefully orchestrated. The transition of the board and the management was carefully orchestrated and is an essential component to getting us here today and the DIP lenders stepping up here today. So I'll grant you, perhaps this is an awkward paragraph, but I think under circumstances regarding the management of the company, it is perhaps appropriate here.
I just don't know what it means, but what I would be comfortable with is saying that provided further that such consent shall be of no further force and effect in the event that the interim order isn't entered or it's reversed on appeal.
That's fine, Your Honor. We'll make that change.
Okay.
Thank you.
Okay, in the next paragraph, sub 8, under the circumstances and given that the above described adequate protection is consistent with the bankruptcy code, including 506B, that seems to be an implicit ruling that the pre-petition lenders are entitled to interest, attorney's fees, et cetera, that they have an allowed secured claim. And I'm not prepared to do that today. So if that reference can just come out.
Your Honor, we'll start that provision with this court finds that the adequate protection right here is reasonable.
Yeah, that works.
Because it then says without prejudice to objections. Okay, thank you. We'll make that change.
Just a note in paragraph, the next Romanet 5, I've got it on page 44. We've got a similar issue on the consent that we just talked about. So we need to add consent shall be of no further force and effect.
No further force and effect. Thank you. We'll make that change.
Paragraph 4, automatic post-petition lien perfection. Doesn't look like it was caught. On page 46, might be 47 here. Anyway, there's somewhere in here that it says that recording officers shall be authorized and hereby is directed to file. And I'm okay with authorized but not directing some recording officer. I think that's consistent with where the court's been for a long time.
Of course, and I can't see it now, but I believe you that I missed it. I see it now, and hereby is directed. We will strike that.
note that this debtor is an LLC, and I'm looking at the challenge language now. And I don't think I see, well, I see a change.
The change, Your Honor, is to make clear that the additional language bestows party status on a Chapter 7 or 11 trustee in connection with any timely challenge that's in process.
Okay, and I like to have in my orders, although I think it will be an issue here, given the change in management, that the language that addresses the Delaware Supreme Court Bax issue.
So, Your Honor, I guess a couple thoughts. I mean, there are a number of corporations here. So, again, in our experience, the Bax issue is where we are solely dealing with LLCs. But we plainly have corporate entities in this document, MS Leisure Company, Gulfport Marine Park, Inc., Marineland Leisure, Inc., Dolphin Connection, Inc. So I think I'd suggest that the LLC Bax issue is not applicable here, given that there are, in fact, corporate entities. That said...
well, we're going to respect corporate separateness, right, as to who has what cause of action. Perhaps, perhaps not, because I don't know how these debtors were run pre-bankruptcy.
Understood. Just one moment on this. So, Your Honor, if we could include the language with respect to the LLCs specifically, perhaps that's a reasonable middle ground here.
Yes.
We'll include that language, and we will say with respect to limited liability debt, companies that constitute limited liability debtors.
Yes.
Okay, very good.
Okay, I do see that we have a provision on cash management, I assume because we don't have a cash management order.
Yes, Your Honor, and the addition there was to make it clear we're not trying to sneak one by the U.S. trustee or anybody, not seeking a permanent waiver or obtaining a permanent waiver of Section 345, as and when we have dominion and control over all the bank accounts. We expect you'll see the standard cash management motion, and it will provide for an appropriate request as we determine appropriate and necessary.
Okay, I see in paragraph 14 that you've made some changes with respect to what happens on a termination event and access to the court. think I had noted in the very beginning of that paragraph, and I don't think a change has been made yet. Okay. Maybe it has. Oh, I'm missing a page. Okay. So I don't know if there were changes made. I'm missing 65 and 66. Were there changes made to in the red line?
No, there's nothing on the red line on those pages.
Okay. Then 67, is that part of 14? What is that part of?
It is. That's part of 14. And again, Your Honor, I must have been sleeping at the wheel.
No.
But we did strike the provision indicating that there's a limitation on what may or may not be argued before the court.
Okay. Okay, in paragraph B of that provision provides that once relief from stay occurs, if agent is granted, granted relief from the stay, to enforce and realize on its DIP liens, it's fine, on all of any portion of the DIP collateral, including collecting accounts receivable, applying the proceeds thereof, and by occupying the debtor's premises to sell or otherwise dispose of the DIP collateral. I guess they can do that consistent with state law, but I have there's some landlord out there who isn't here and may have an issue with that. So as long as it's consistent with state law.
Okay. Can we say consistent with applicable law?
Yes, applicable law.
Thank you. We'll make that change.
There's a lot of that in EIC, but it's all subject to the next E. It's all subject to entry of a final order. I'm reading it. hitting more of these provisions. Survival of interim order. And they all read a little differently, but they don't seem to contemplate what happens on a final order. Like, how does this interim order survive if I have a final order? To me, and the reason I take care with these interim orders to the extent I can is because I've had a couple cases where I never get to a final order, and then it really matters what the interim order says. Most of the time we get to a final order, and that's negotiated, and so that should supersede the interim order. But I'm not sure this says that. It might, but like it governs in the interim, but once I have a final, at least I think the final order should govern.
That's fine, Your Honor. We'll add language indicating notwithstanding the foregoing upon entry of the final order shall govern.
Okay, paragraph H, inconsistency, which is page 83 of the red line. This is, I don't want there to be any inconsistencies in any orders, and those first day orders need to be complete. So, so I really don't like this language, but I just want you to put consistent orders in front of me. Okay?
We accept your admonition.
Okay. That's all the comments I have. I'm not going to take the blame for this many comments because when you give me an 80-page dip order, then you get what you get.
Your Honor, I was ready to challenge Cory Booker's
Did I
time
say that
here.
from the bench? I think I just did.
Your Honor, I was ready for far worse, but my
well, then
my
I wasn't
filibuster
up to-
time
I
is
disappointed
certainly
you.
short of
Okay.
what I was ready for. So thank you, Your
Okay.
Honor, for all the attention to this. We appreciate the time and effort.
Let me ask, does anyone else want to be heard? There we go, Mr. Hackman.
It was. Your Honor, let me note, there was a change, and it may not have showed up in your black line. There's language in paragraph 20A that we are taking out, and it will appear in the black line that you receive with your other changes. Paragraph 20A had language stating that the proposed final order shall be substantially the same as the interim order, except that provisions that are interim shall be final. U.S. Trustee had concerns with that.
I missed that. That's why it's good to have a second set of eyes on these things. Thank
Your Honor, you can be assured that Mr. Hackman did yeoman's work.
I have no doubt.
In fairness, but we are striking that language. You'll see that stricken in the
Thank you.
In the final order, or in the final interim order.
Thank you. Okay. I will approve borrowing on an interim basis in the amount of $4 million as it's set forth $1.5 million, and then a budget and the other $2.5 million based on the uncontested testimony that I received through the declaration. Clearly there's a need for financing. There's a need to do it on this unusual basis without a budget, without fully knowing the finances of the debtor, but under the circumstances of this case, there's no option. And I find that it is necessary to enter this order to avoid immediate and irreparable harm.
Thank you, Your Honor. We appreciate that. We'll work with DIP lenders to revise the order and submit it under certification of counsel.
Very good. Just let Chambers know when that's done. We'll get it signed.
We will, Your Honor.
Thank you. That's all for today? Or do we have anything else? Oh, we need a second day, don't we?
We do need to talk scheduling.
Okay,
Oh.
let's talk scheduling.
I know that's painful with you, and I've experienced it myself, so apologies in advance. You done? So, Your Honor, maybe I'll just lay it out. So my understanding is that with the milestones under the order, our deadline to have an entry of a final order would be May 5th. I understand that that is not convenient for Your Honor, and I understand why. And I also understand that the next week is you will get to see lots of me the week after that. So let us know what works for you.
I'll take you on May 5 at 10 o'clock. And I'm hoping it won't be super contested, but if it is, I'll deal with it.
Thank you, Your Honor. I guess another request, and we can certainly work through Your Honor's chambers. We're hopeful that we will have a set of operational first day motions in short order. Our hope would be to file those and seek a hearing, a further first day hearing, possibly next week. And again, facts are fluid here. Facts are incoming. So I guess if Your Honor has any guidance as to when the court may be available, that we could help to sort of shoot at a date certain, that would probably be helpful guidance for us.
For an interim traditional first day?
For a traditional first day hearing.
And you're thinking next week? Looks like Tuesday's the best day. Is that possible?
Well,
The alternative is just reach out. Just reach out when you know you have the set that you want. And I'll find somewhere to put you in. I tell you, in April and May, I'm going to be squeezing people in, and some of it may be at 9 in the morning, and some of it may be at 6 in the evening, but we'll get people in that need to be in.
fortunately, Your Honor, Mr. Brady's a morning riser, and I'm a night owl. So
There you go.
we'll work it out. Thank you. We appreciate your cooperation and assistance with today's hearing and what's anticipated to be future hearings that may be challenging, but well, we look forward to the challenge, and we hope to do right by this company and by its animals.
Very good. That's it then for today. We're adjourned.
Thank you, Your Honor.